Good day. I'm Gerald Goldfarb, and this is our television discussion show entitled Inside Law. What we try to do in this show is to have discussions with interesting legal personalities in the Los Angeles community in the hope that we can give the ordinary person in the public an inside view about how the legal system really works. I'm a practicing lawyer in Los Angeles, and our guest today is a retired Superior Court judge, recently retired, the Honorable Raymond Choate. Judge Choate, thanks very much for being with us today.
Thank you for inviting me, Jerry.
You're welcome. I want to say a word about Judge Choate before we get down to some discussion about the interesting legal issues in our community these days. I met Judge Choate when he was a Superior Court judge and appeared before him on numerous occasions and got to know him, found him to be very able and a very fair judge, and since he's not sitting there, I can say nice things about him and not be accused of trying to get any advantage.
Cause and favor.
That's right. I'm not doing any of that. Judge Choate started his career as a public defender in San Pedro. When San Pedro was a pretty rough town, I understand they had whorehouses over the bars in San Pedro at that time. He was appointed, he was in private practice for about 10 years, was appointed to the municipal court bench by a Democrat governor, Pat Brown, and then in 1967 was appointed by Ronald Reagan to the Superior Court bench, where he sat for 20 years until he retired recently. And I'd like to start off the questioning by asking you how it was you got both a Democrat and a Republican to nominate you for judgeships. That doesn't seem like the ordinary situation.
Well, I'll just say what I said to many of my friends who asked me the same question back in 1967 when Ronald Reagan appointed me to the bench, to the Superior Bench, after Pat Brown had appointed me to municipal court. It was a merit appointment.
Well, I don't doubt it at all.
If you can believe that.
Now, did you have to get appointed to the bench? I grew up in New York City, and in New York City they tell me that...
Don't complain to me, Jerry.
Well, I'm trying, I think I was bragging, but maybe not. In New York City they used to tell me that to get a judgeship you had to pay thousands of dollars under the table to the Democratic machine. That's the rumor anyway. Now, did you pay thousands of dollars, Judge Choate, to anybody? Or how did you go about getting a judgeship?
Well, I didn't pay any money to get it, but I wrote a lot of letters to people and let them know that I was interested. Mm-hmm. And I was more or less surprised when it came along, mm-hmm. really.
And I think that's how most people get judgeships in California. We have a much cleaner system than they have in the East, don't you think?
I think so, from what I've heard. And of course, Pat Brown and Governor Reagan were very astute men.
Mm-hmm. That's right. There was a lot of criticism, really, when some of the more recent judges that Jerry Brown appointed, but I don't think that's probably a sidelight we don't need to get into.
I don't think we need to get into that.
Right, right. After 20 years, really, on the Superior Court bench, can you give the public some kind of overview about what changes you think have occurred and what effect they've had on the administration of justice for our citizens?
Well, I think that in the 20 years that I've been on the bench, the society has grown immensely more litigious. By that I mean that the caseload has grown greatly throughout the state, and the numbers of lawyers have increased immensely. There are more women lawyers in court these days. There are female lawyers who do extremely good jobs as trial lawyers, something that we didn't have too many of when, that is, women trial lawyers when I first mm-hmm. started. Mm-hmm. The caseload is still roughly the same in relation to criminal and civil, except that with the addition of the narcotics cases and the gang cases, the gang-oriented cases, in criminal law, there are more of those than there were before.
When you started in the Superior Court in 1967, drug cases were just beginning, I would guess, to be numerous, and now
they were very unusual then, and now they're very numerous.
Mm-hmm.
As a matter of fact, with the drive that the district attorney and the police department have been conducting in the past several months, the courts have become crowded with drug cases.
Mm-hmm. Do you think the Fourth Amendment has suffered or has held up as a protector of people in the light of all of these drug cases?
Well, when I came onto the bench, there were a few cases involving the Fourth Amendment and some restrictions on the production of evidence or the use of evidence that was seized by the police. But it then took off. The Fourth Amendment cases took off, and there was a rather liberal period in the appellate courts and in the Supreme Court. And I really think that it became an unreasonable kind of a situation, so that an officer in the field couldn't tell when he was in violation of the Fourth Amendment and the defendant's Fourth Amendment rights, and when he was not.
And the pendulum has sort of swung back in the last years, hasn't it?
It has swung back, and it swung back as a result, I think, of public pressure and public awareness of the problem. And they voted in California for Proposition 8, and now instead of the California Constitution ruling the United States Constitution and the Fourth Amendment of that Constitution and the cases that follow it are ruling.
Mm-hmm. As a practicing lawyer, I've always been and am very much concerned about the crowdedness of the courts. And I remember an occasion, I believe it was the last day that you sat as a judge. By coincidence, I was in the Santa Monica Superior Court.
About June 15th.
About June 15th. It was a Friday afternoon for a trial-setting conference. And when I got to the courthouse and I got to the courtroom that I was supposed to be at, I thought they were playing a popular movie, because there was a line of lawyers coming out of the door and winding all around the building. And then when we finally got in there, it was quite crowded. There were over 100 lawyers trying to do business and only one judge. And it seemed to me like this was probably not the right way to run a railroad. How do you feel about that?
Well, I'll tell you, you wandered into what's known as a trial setting and status conference. And it's true that there are about 120 cases set, and maybe 80 of those cases. In 80 of those cases, the lawyers will show up. Mm-hmm. And it does resemble a stampede, a cattle call. And I can understand your dismay at finding yourself at the end of a line in an afternoon and not knowing how long it's going to take you to get out of there. But although it could be done by telephone perhaps, we felt that to have a judge face the lawyers, find out what the case is worth, and make a determination as to whether or not the case would stay in Superior Court or be diverted to an arbitration if it was found to be less than $25,000. To have a judge do that was beneficial to the calendar, and it worked out well.
It worked out well in my case because I found my adversary, and it was Friday afternoon, and we were both anxious to get out of the courtroom and start our weekend early, so we made some sort of an arrangement that was satisfactory for both. Well,
at that trial setting conference, if a case is found to be less than $25,000 in controversy, the judge can shunt it off to arbitration, a mandatory arbitration. And although the arbitration is mandatory, it's not binding. So if one of the parties does not like the result of the arbitration, he can ask for what's known as a new trial, a trial de novo. But the fact is that once that determination has been made by a judge sending it off to arbitration, only about 15% of the cases that the judges send off that way come back for trial. So it's been very valuable.
And so this mandatory arbitration is a method to process cases and bring them to a conclusion more promptly. That's basically what it is.
That's true.
And which brings me to another thing that I want to ask you about, was the problem of delay. Now, in the Superior Court, the public should know that the Superior Court is the court of general trial jurisdiction in Los Angeles County. If you have a business dispute or a divorce case or a probate case or an automobile accident case or, God forbid, a legal malpractice case, you go into the Los Angeles Superior Court, and you can get anything from $25,000 to millions of dollars, depending on the case. But it takes nowadays, for many cases, 5 years from the time you file a case until the time your case would come up to trial. And in fact, I think the public thinks that these cases come to trial, but do many cases come to trial, really?
I would say that probably only 15 or 20% of the cases get to trial finally, because most of them settle. I don't know the reasons for delay. I think that the answer is about as broad as the interests of our society are broad. The reasons, I suppose, for one, is that there are enormous numbers of lawyers in the state of California. California has, well, it had when I first entered practice, it only had about 20,000 lawyers, 15 or 20,000. It now has over 100,000 lawyers, and 15,000 take care of Japan, for example, the entire nation of Japan. But California has 100,000. And more lawyers, I would imagine, generate more cases. And then, of course, the law has changed greatly in the last 20 years, so that there are new causes of action, as you know, Jerry. Bad faith, breach of contract, bad faith insurance cases. Those cases come about, the new law comes about not only as a result of legislation, but as a result of appellate decisions, as you know. So all of that has made for new law, plus, I mean, for greater crowds in the courtrooms and for greater numbers of cases. And I think it will continue to be that way so long as our society heads in the same direction.
Yeah. It's an interesting cultural difference. You bring up Japan. When I was a law student, I spent a summer working for a law firm in Tokyo.
You did.
And
it doesn't show on you at all.
It was a lot of fun. I learned really certain different ways of doing things.
Did you learn any of the language?
I could only count to 10, Judge. That was the extent of it. Excuse me, a few other words. It's a hard language. But the difference in litigiousness between the Japanese and the Americans in commercial ventures, for example, is enormous. When I was in Japan, the very suggestion that somebody ought to sue somebody else was quite hooted. I was hooted down by experienced lawyers, while in California that's almost a reflex.
Well, it's considered impolite, I think, to sue in Japan. I'm not sure, but there's no such hesitancy in the state of California.
It's true. Now, I know that there's a lot of methods being used to speed up the pace. They say justice delayed is justice denied, and I think there's a lot of truth to that, but I know that the lawyers are trying to speed up the system, and one way is a new method, which is to assign a case to an all-purpose judge. The public may not understand that. When a case is filed, it's just in the Superior Court usually, and it doesn't get to its trial judge until the time of trial. The federal courts have always had a different system, where a case was assigned to a judge immediately upon it being filed, and that judge shepherded the case through the system. Now, in the federal court, you can get to trial in 2 or so years, I think, and it's a lot shorter time than in the Superior Court. So I think they're starting that system or introducing it here. How do you feel about the all-purpose judge?
I think it's worth a try, and I think that probably it will work in Superior Court, provided that the numbers of cases, which are, of course, many, many more per judge than the U.S. District Court will ever have, I suppose, but provided the number of cases per judge is not too many, because the federal system has judges who are assisted by law clerks. I don't know whether there are going to be sufficient numbers of law clerks to assist the Superior Court judges upon whom this load is going to fall, but if they have the proper support, I think it will work. It appears to me that the program has many advantages. One is that a judge gets to know the case. He might be carrying 300 cases, and it might be more difficult for him to know one case from another after a while if they're at all similar, but a good judge can, I think, shepherd those cases, as you put it, and put some of them to settlement before the trial starts, and can cut many corners in discovery and in law and motion matters.
Mm-hmm. Well, I hope it works out that way, because all of us, clients and lawyers alike, want these cases to go through the system and reach a resolution quickly. One of the worst things about a case sometimes is if it hangs on for too long, the people may suffer from the delay.
Oh, surely. It's I think it's true that justice delayed is justice defeated, particularly in the case of, say, a personal injury or a contract loss. People shouldn't have to wait until judgment, 5 years for judgment.
That's right. I had a case before you once of psychiatric malpractice, you might remember. And
I recall that case. And
the delay was such that it really had an unfortunate effect on my client. She couldn't get on with her life. She was still waiting for this lawsuit, which was hanging on.
I've heard of that syndrome, the litigation syndrome. People are just waiting for the time when they can get to court, and nothing seems to happen in the meantime in their lives until after it's over.
Right. And then sometimes they recover fast. That's another odd syndrome. One of the ways people are trying to increase the speed of the system is to get more judges, and I noticed the LA County Bar Association, I think, recently filed a lawsuit against the Board of Supervisors, trying to get the board to provide more judges. It seemed to me that that was not the wisest approach. I think the public, which is feeling some discontent with our profession these days, kind of thought we were over litigious for the lawyers to be suing the Board of Supervisors. How did you feel about that?
Well, it's one more lawsuit that we can take care of in the Superior Court, but I think that may not be the way to handle it, because there are ways to go about it which the prestigious Los Angeles County Bar can adopt, which are much better, I think, than filing a lawsuit. The pressure of the lawyers of the Los Angeles County Bar on the legislature and on the Board of Supervisors, if they were to exert them to have more courtrooms and have more judges, would be, I think, a better way to handle the problem.
We do need more courtrooms and judges. We certainly need more courtrooms just for the number of judges that we have now. Again, I'm in the Santa Monica Superior Court from time to time, and some of the other courthouses too, and the number of judges are too large for the courthouses in Santa Monica. There must be at least 4 or 5 judges, maybe more, sitting in sort of trailers, makeshift courtrooms that are basically trailers and have been decorated like a courtroom. And I just think the solemnity and seriousness of the adjudication of disputes is sacrificed when we have court trailers doubling as courtrooms.
Well, for a long time, right alongside of the Hall of Records downtown in downtown Los Angeles, at Broadway and Temple, there were some bungalows that were placed there just after the war, in which domestic relations cases were tried. There were about 10 bungalows, I believe, and they were really made use of. And as to those trailers, we were happy to have them out in Santa Monica. That came about when we were thinking. I was a supervising judge. I was supervising judge 4 years in Santa Monica. And at one time, we were thinking about trying to persuade the Board of Supervisors to enlarge the courthouse and revamp it, put some more courtrooms inside of the present structure. And I mentioned that to Frank Zolan, who is a very capable executive officer of the Superior Court. I think one of the world-renowned authorities on how to run a court system of this size. I think it is the biggest court system. But anyway, Frank Zolan said, you're pushing to have the courthouse revamped. Why don't you accept some trailers? And I said, what are trailers? And he told me that, well, they put 4 trailers together, 4 house trailers, kind of a thing, to put 4 of them together and you can make a courtroom. So I said, sure, we'd be glad to get anything in which to try a case. And if you provide us with space for jury trials, I'm sure the juries won't mind. So in a very short time, he had about 12 big trailers moved in there. They put them in with cranes and lowered them into place and put them all together, and we had 3 more courtrooms that we didn't have.
Maybe it's not so bad. Maybe it's an example of simple living. We all have to take a little simpler living.
There was one little problem, though. They forgot to insulate the walls so that when the jury assembled in the first case, we could hear everything that they were saying in the jury deliberation room. It cut down the suspense on the trial, I'll tell you that.
It did.
On the outcome of the trial, that is. We corrected that, though, so that it has all the comforts of a regular courtroom.
Well, I always thought there was a certain discontinuity about it. They were adequate, all right, but some of the lawyers were coming from law firms whose offices are like palaces, and then they were going to a trailer for adjudication. Something seemed a lot of
quite a come down for them.
That's right. Yeah. That's right. I mean, the law courts ought to be at least as imposing and impressive as these lawyers' offices, I think.
I agree. It should be at least as imposing and as impressive as a real estate office.
That's right. Yeah. That's right. Now, I know that I'm interested to ask you about what you're doing now. I know that you retired recently from the court. And I want to know why you retired, partly. And I also want to know, I understand you're now working as a rent-a-judge.
Yes.
And I'd like you to tell us a little about that.
Why I retired?
Yeah.
Well, I retired because I was becoming advanced in years, and
with that head of hair, Judge, it's hard to believe that.
And I wanted to take off from the bench while I could still be useful to myself in the rent-a-judge business, and those are about the only motives I had. But I joined the Judicial Arbitration and Mediation Service, which had been run for some years by Judge Knight out in Orange County. Warren Knight was a Superior Court judge who left the bench, and he opened the Judicial Arbitration and Mediation Service there. And I kept hearing, as I was a judge, a working judge, about that service. People would go out there to Orange County, travel all the way from Los Angeles County in order to go out to settle a case before Judge Knight.
Well, does this system is sort of an alternative to the normal Superior Court. If you don't want to be involved in the Superior Court, litigants can actually hire private judges to handle their disputes.
They can agree upon a judge, and by stipulation or agreement, they can go to that judge, and the code provisions, the Civil Code of Procedure allows the cause to be submitted to a judge.
And then they don't have to wait for 5 years. They can hire a judge. They pay the judge, like yourself.
Yes.
And instead of waiting 5 years, they can get justice promptly.
That's true. And with a little bit of urging, occasionally a presiding judge or a supervising judge can even provide a courtroom and a jury for the rent-a-judge to sit in, to a courtroom for the judge to sit in with a jury. As a matter of fact, I'm scheduled to do a malpractice case very shortly before 2 good lawyers, and that's always a pleasure to have 2 good counsel in trial. And the county is going to provide the jury and the court staff. In that way, if a judge is on vacation, the courtroom isn't wasted, and the jury is available. Members of the jury panel are available at any event, so we'll make use of them.
I remember when Rose Bird was Chief Justice, she was skeptical of these programs because she felt it was a dual track was existing: ordinary justice for the ordinary people and kind of special high-quality justice for those who wanted to pay the money to rent a judge.
Well, she felt that the poor were being discriminated against in that they had to wait for 5 years, and the rich could pay a judge to sit and hear the case. But on the other side of the coin is the thought that in taking a case out to a private judge, in so doing, room is made for the trial of other cases perhaps of a poor person.
And these really a relatively small number of cases go out of the system and rent a judge. Isn't that true?
I'm not sure of the statistics now, but what you have to consider is that there are a great number of voluntary settlement conferences through rented judges. We handle voluntary settlement conferences in this judicial arbitration and mediation service. And Judge Knight has expanded his service so that he has a San Diego office and he has a Los Angeles office now, and I work in the Los Angeles office.
Well, this is the free enterprise system. A felt need for special services exists, and the system has provided it, and has provided it with excellent judges like yourself. So I don't think we can complain about that. I think we're pretty near to the end of our show this afternoon.
Are we?
And I want to thank you very much, Judge Choate, for being with us. It's been a very interesting conversation. I think we've learned a lot.
I think it went very quickly.
Yes, it does go very quickly. It's interesting. And I want to thank the public for tuning in, and I hope this has been useful. This has been Inside Law. I'm your host, Gerald Goldfarb. My special guest today was the Honorable Raymond Choate, and we've discussed the Superior Court, and we are very happy to have had you all with us this afternoon. Thank you very much. For more information, questions, or comments, please call Inside Law at area 213-285-8599.